First item on the agenda, number 1, alternative dispute resolution considerations. Read council investigatory hearing and actions.
Mr. Mayor, I prepared this agenda. This first item appears to have no interest among council. You're willing to discuss it. All lawyers should seek to resolve disputes. All lawyers should seek to find compromise. I suggested alternative dispute resolution, including mediation. Council may discuss it. What is your pleasure?
Well, I'm just going to talk for me. I think we spent enough time and enough money on this situation. I think it only rises, if it rises at all, it rises to the case of an ethics problem, and not just this. I think we could have resolved all of this through ethics board, and we could not have had the expensive lawyer fees and other fees that we have paid to this point. So anyway, we can resolve this, saying through ethics or, or whatever, we're paying more money, I will be with that 100%. This is my case. Okay, Ms. Gomes, and then Ms. Gilliard, demonstrate.
What were the alternative dispute resolutions that were provided?
I have not provided any alternatives. I'm merely making a suggestion that in any dispute, in any civil case, and in some criminal cases, you should always consider efforts to resolve the dispute. To answer your question in broader terms, Councilwoman Jones, the alternative dispute resolution is only restrained by your imagination. The most common form is what's called mediation. Mediation is a proceeding which is voluntary. It can be ended at any time by any of the parties, and it's normally conducted confidentially. Again, that would be an issue you could waive or not waive. I made the suggestion because I thought it was a good idea. I made the suggestion at the end of the case. If it's a bad idea, I apologize.
Thank you.
Ms. Gilliard?
We heard a little teeny bit of facts, enough for us to ask for an investigative hearing. We knew that that was going to cost a certain amount of money, but we knew that it was important to get the facts and the truth and to hear everything. We haven't done that yet. We spent a lot of money. I don't even know what happened on December the 10th. I know some things happened that shouldn't have happened. I do know when we vote, it becomes law, whether the mayor signs the document or not. And that was part of what was said at the end of that hearing. And then it was closed down. So every time we get to the point of wanting to get to whatever the facts are, it gets shut down. So sometimes you have to spend money for the truth. You spend it for other things that people want and say they need and justify. So being the person that constantly talks about finance before I became a council person and will always, until I leave the seat, I think the money is worth it. And I also know that more money was spent getting someone to preside over the hearing so that it would be cheaper, so that it would take less time, so that we wouldn't spend a whole bunch of time talking and spending more money for attorneys. None of that happened. So I'm good with it. I want the facts. I want to know what happened. I want to know why. It might be something that is not really that bad when we find out the facts. So I can't make up my mind without any data and without any information. I think that that doesn't make sense.
Okay, Ms. Jackson, then Ms. Rao.
I think suggesting at this point a mediation is mute because we as a city, we are a new city, for 2.5 years, some of us have been appointed and painted to be the cool individuals in the council. But I think it's time for the residents of the city of South Fulton to find out the truth and to know exactly what is going on in their city and to know where problems arise and where they are. Sincerely.
Okay, Ms. Rowland, then Mr. Khalid.
I want to thank you for the suggestion for mediation, but I too think at this point, there's been so much information out there, it needs to be presented in a way so that the public can see the process. I also am very interested in getting to what happened one way or the other, and I do think, though, we need to look at making sure we're good stewards of the public's money.
That's right.
And this particular case should have gone to the ethics board in the first place, in my opinion. Each member of this council has a person appointed. I think it's maybe 5 or 6 attorneys on that. And based on, I believe that body would provide the opportunity for the information to be presented, and it also wouldn't waste the work that you've done gathering information. So I hope our council will consider that, because those meetings are also open to the public, whereas I think a mediation wouldn't allow that.
Okay, Mr. Khalid.
So I have a couple of things. First, Mr. Donald, when we went to, not Sandy, Chateau Elan, how much did we pay for that mediator? It was like $7,500, $75?
It was $5,000.
$5,000. So when we went to Chateau Elan for a council retreat, we paid $5,000 for a mediator to come for 1 day. We made agreements, and at the very first council meeting back from Chateau Elan, we broke the agreement. So I am not interested in wasting money on mediators to make agreements that we have no intention of keeping. Second, I find it interesting, Councilwoman Rowell, that you think that this should have gone to the ethics board, because when we held the vote, you voted for this hearing. We voted 6-1 to have this hearing. I do agree with the mayor that we have been wasting money. Because the truth is, if the people who have been named in these charges would simply testify under oath, we could be done with this. Many of the people that have been named in these charges, they've given interviews, they've talked to the media, they have given town halls. But when we ask you, come in here and say what you said in the town hall, on camera, in public, under oath, now everybody wants to lawyer up. I think if what you have been telling everyone, because people have been telling their sides of the story, tell it one more time. Swear on the Bible, tell it one more time. We could do that today. We have a process server here, do we not, Mr. Morosi?
Yes, Mr.
Okay. Okay.
Please stand up. This is Haile Kasu. He was hired because of the necessity of serving process which would not be accepted by some people.
This is the third process server that we have hired. But the people we're serving subpoenas to are right here in this room. They're going to talk today. Just talk under oath. That's it.
Okay. Anybody want to make a motion? Mr. Baker, go ahead.
I think my colleagues said everything that needed to be said, especially Councilwoman Gilliard. Thank you for your sentiments. I would love to entertain a mediation. However, I have newly formed concerns that have come up since we've started the investigation. And since this investigation is about the Development Authority and the possibility of projects being steered out of the way, and I'm hearing and learning of a project that started a week after we started the investigation in the same district that never came my way as the chairman of the Development Authority, to the tune of $19.5 million. I had our financial advisor, Ed Wall, share the information with me, and I've learned that the city stands to lose $3 million by not doing this deal. So if you add that $3 million with the $7 million, I just feel like you guys deserve answers. I know I would love to know what's going on as the chairman of the Development Authority. We have people who have volunteered their time to work for this city, and they come from you guys. And they know nothing about the deals that we find out from Fulton County that's going on right up under our noses in our city. And regardless of how it's happening, why it's happening, all of us speak about transparency and accountability. It's just unfair for us to leave you guys in the dark while we remain in the dark as well, and say we're going to just sweep it under the rug and say we all have things we need to change, or this is a personal vendetta. And the thing is, we've dealt with as a council so much that you guys will never hear of, because we deal with it and we take it on the chin. And it's just so much that happens. But when it comes to the point where it starts impacting your dollars, it's only right, regardless of how we're demonized, it's only right that we all know what happened. It might be nothing. It might be nothing. And it might be everything. And it might cost us even more millions of dollars in the long run. We just owe it to ourselves and you to know. I get it.
You good, someone? Okay, good. I'm going to have Ms. Willis, and then I'm going to end with Ms. Riles.
Well, Mr. Donald, did you, I think the second project, which is this $19 million bond inducement, did you explain how that project came about? I think there were some inquiries made about that project, and didn't you explain that that project never did come? Neither one of these projects really came to the city, but didn't you explain how that project came about?
Point of order, are we having a hearing now? 'Cause we need to get to, we need to have you testify.
You're out of line.
My question was posed to Mr. Donald, the city manager, who's
So we've
responsible for the day-to-day
We've had
operations.
no conversation outside of the executive session, and so any conversation that we've had in executive session, I think the council is fully aware of that.
Okay, and so the other thing is, I think it's wrong to continue to sensationalize the untruth that $7 million is being steered outside of the city or even outside of this county. And it's almost slanderous.
All right, Ms. Riles.
I want to respond to a couple of things. One, I think when this first came and Mr. Morissette came to us, I think I probably did the most questioning about sharing executive session, and I asked, was there anything criminal in terms of what you had discovered at that point? You said no. I don't think any responsible council member would have said on this DS and not said that we should vote to have a hearing when he said that he felt it was enough evidence to move forward. Now, what I will tell you, while some people may know what's going on, we all don't have the same information sitting up on this council. That is quite clear. Some of this information came after our hearing. If you recall the second meeting, I wasn't present, and then we got something that enumerated some charges by email. It was the evening after. It wasn't during the meeting. And I verified that it was nothing handed out at that meeting, that the document that I got. I think that came at 7 o'clock that evening. So again, I really want to understand who's directing this investigation on this council. I really want to answer, because again, everybody up here doesn't have the same information.
Is there anyone wants to make a motion for a resolution of what we have before us?
I'll make a motion to dismiss this mediation and move to the next item on the agenda.
Second.
Properly moves in second. Discussion? Hearing none, all those in favor? That passes 6-0.
6-1.
Mr. Clerk, go ahead.
Next item, item number 2, council investigatory actions, including December 30th, 2019 investigative hearing. Letter A, consideration of waiver of first Roman numeral, attorney-client privilege as to communications between Councilmember Willis and City Attorney Emilia Walker.
I would like my counsel to speak on this, if you don't mind, Mayor.
One, I don't believe that an attorney can waive attorney-client privilege. As you know, we kind of vetted this a little bit during the hearing with Judge Moore, and she spoke to it. Counsel now spoken to it, although he agreed with me in person, personally. When he's before you, he seems to have a different tone. And let me be clear. I have before me a couple of things, and I've done this on more than one occasion. This is what I do for a living. I have a resolution, I have a notice of public hearing. Let me try to help out, and my client may beat me up a little bit for this afterwards, but we're gonna always come back to this being starting over because it's not being done the right way. Unless, and I don't remember council contacting me stating that this resolution was prepared by anybody on this council, nor was I even involved in it. Nor did he give me a notice of a public hearing or the charges, even though he added one. So on tomorrow, if you pass this, I'm going to the Superior Court of Fulton County and file an injunction. So I'm really trying to be honest with you and be transparent to say, you paid him $20,000 and everybody can look like this. As opposed to that, let's find somebody who can accomplish this the way you wanted it accomplished, because I thought that we were supposed to be a part of the process. One, you cannot have a person who waives their attorney-client privilege. It belongs to the client, not to the attorney. The state bar is clear. If it happens, we'll deal with it. A text message between she and the attorney was a text message apparently about something that they believe they needed to discuss. But I don't believe that a body can waive an attorney-client privilege. I also don't believe that a resolution that has not been prepared or have input by a majority of council can be put before this council to be investigated based on your own charter. I also don't believe that the notice of the public hearing for removal can be put before this council pursuant to your own charter without you all being involved in it. That seems to be an incredible amount of things that are happening without me even getting a telephone call. And according to your charter, my client is still a member of this council and is entitled, if you will, to be a part of the process. Thank you.
All right,
Mayor,
Mr. Clerk. You can.
Thank you. First, let me say, in my 36 years of practicing in 4 states, I generally always return phone calls. It seems to be unproductive with Attorney Wings. He called me Thursday night after hours. I took his call. It was almost an entirely unproductive phone call. With about an hour into the phone call, I said, 5 minutes, Antavius, let's be productive. 4 minutes, 3 minutes, 1 minute, good night. The resolution I prepared, as happens all the time with this council, you'll have complicated financial resolutions and ordinances that are prepared by others. I prepared it, and I did send it to council, all members of mayor and council, everyone, half an hour before the hearing. Half an hour before the hearing. Now, is this expensive? I think when you're considering the expense of this proceeding, you need to look in the mirror. That's what's causing this to be drawn out. I thought my assignment would be done on December 10th. Matter of fact, I wasn't so sure there'd be a hearing, but I assumed that my assignment would be done on December 10th. So I respectfully disagree with my brother at the bar. As to the attorney-client privilege, it is black letter law. It is clear law that the attorney-client privilege for the city council, the city of South Fulton, is held by the council and not an individual. And these are decisions that may or may not be made by you in your discretion. Makes no difference to me. But the point is, These decisions and others need to be made by council with a majority vote. Thank you.
Thank you, sir. Mr. Khalid?
I just want to make note for the people in the room that we have an attorney that is willing to go to the Superior Court of Fulton County, not to argue the facts, but to make sure that you don't hear them. So, Councilwoman Rao previously said that everyone doesn't seem to have equal knowledge about what's going on. Councilwoman Willis said that the number $10 million is false. If only there were some way to have a public hearing to figure out who's telling the truth and who's not. We want to ask Odie questions, but not under oath. People want to debate the facts of the case, but not under oath. Not under penalty of perjury. And right now, I want you to know that for the next hour or more, we won't be discussing the facts of the case. We'll just be discussing whether or not you get to hear them. And you should know that that's what's happening in this room right now. There are people that are fighting to get you the facts, and there are people that are fighting to keep the facts from you. Now, to cure this problem with the resolution, it's actually not a finished document. There are many blanks in the document. I would like to make a motion to yield to our special counsel that has been appointed by a majority vote, if he would present this resolution to us and to the public, and then share a discussion about how we write this resolution. We're going to write this resolution in front of you on camera right now. If I could get a second for that motion.
Second.
Properly moved and second, in discussion. All those that, okay.
Yes. Well, I mean, I support my counsel for filing an injunction because this is not a fair and this is not an objective process. Several residents overheard an attorney that was hired by Steve Fincher, not hired by Steve Fincher, that was sent to us to prosecute and persecute me by Steve Fincher. He admitted that he was sent this way by Steve Fincher, which is a partner of our city attorney. He said they go way back. And so if you want it to be fair and objective, then what should have happened is, one, it should have gone through ethics where no one on this council would have been compromised. The second thing is, if you wanted to bring in a counsel that did not have any type of relationship with our city attorney, then you should have had somebody neutral procure somebody that did not have a relationship with our city attorney. This process is not fair, it's not objective, and it has been said several times there was nothing illegal done. And if you continue to say that I steered $7 million out of this city without hearing all of the facts, again, I would ask my attorney to sue people individually for slander.
May I respond, Mr. Mayor?
Yes, you can, but briefly, because I want to get this
I would respectfully disagree with what Councilmember Willis said. In the 36 years I've practiced law, I don't know of a lawyer with whom I have a worse relationship than Steve Fincher. We are not friends. We had a case a number of years ago, and I had him disqualified. I have not spoken to Steve Fincher. I believe the reason he chose me is because he thought, or you say he did, I assume that Attorney Walker chose him, they're partners, but the simple reality is I was chosen because I was tough enough to handle this. And as to the issue of fairness, let's focus on what the legal standards for fairness are. The comment about the criminal conduct, I did not say there is or there is not evidence of criminal conduct. I wasn't asked to find any. If I did, I would contact the district attorney. That wasn't my mission, and I'm not saying that there is or is not criminal conduct. I do not know. I wasn't asked to do that. But the standards for this hearing are very clear. It's the 14th Amendment of the U.S. Constitution. And as long as you retain me as your special city attorney by majority of council, I'm going to follow the Constitution, I'm going to follow the rule of law, and I'm going to follow the rule of ethics.
But I was also, Mr. Mayor, I still have the floor. I still have the floor on adjournment.
It was on that list. Go.
Okay, thank you. Can you put it down again?
I want to be clear about the money. Because emails have gone back and forth about, oh, we're spending this amount of money, we got paid 20, he said 13. But it involves having a court reporter. And the awful part about it is the processor trying to serve people who duck, which costs more money. So it's not as clear cut as it might seem to just throw out a certain amount of money. Yes, we have spent it, and we keep doing this. We keep going around and around and around and around. The facts are going to come out one way or the other. There might not ever be a hearing, but they're going to come out. They're going to come out as soon as the project begins and over a period of time. So let's be clear, a period of time. $7 million will go to Fulton County that should have come to the Development Authority of the City of South Fulton. And lastly, since, well, way before then, but especially after May 1st, 2017, Fulton County has been in our pocket and continues to be. I'm finished.
All right, Mr. Baker, go ahead.
Yes, I'm noticing how stuff working. I feel like a slow learner right now because we do this dance in front of the audience and you guys, sometimes you hear things and it moves you. And I see how it moves you when you found out how our attorney was hired. But I just want to ask our attorney for counsel, what does the charter speak to the hiring of outside of attorneys or how are attorneys hired according to our charter? What's the process of bringing Morosic here and whose responsibility?
According to the charter, it would be my responsibility it would be my general responsibility designated as the city attorney to represent the city in this circumstance. When this first came up, I did advise the council that it was not my intent to represent the city, and it was not because I have a legal conflict, because I feel like I can't represent the city because a council member is involved. If you would like to know why I don't want to represent.
No. I don't want to get into that. I just want to know how. I just want not even that. This is just for the edification of the public. I want them to know whose responsibility is it to hire outside attorneys.
So it's my responsibility. I asked you guys to allow me to delegate it to an outside party. When you gave me that authorization by motion,
right.
At that point,
I think that that's the only thing I want the public to know. According to the charter, it's our city attorney's job to hire outside counsel for us. That's her right according to the charter. That's what we've empowered her to do. So I don't want you guys to think it's an inside job and somebody just placed an attorney here to be ferocious towards one of our own. That's not what happened. And I would like to call the previous question.
Second.
Probably moved second to call the previous question. Let's vote. That passes 5-2. Motion on the floor for the original, on the vote on the original motion. You want me to read your motion again? Can you have moved the resolution?
Motion by Councilmember Khalid, seconded by Councilmember Jackson to put forth the resolution, City of South Fulton establishing an investigative hearing regarding Howard Steak and Seafood letter of inducement with the Fulton County Development Authority and the establishment of an investigatory hearing to consider sanctions against and to have the Mr. Morosic go through this document and fill it in.
All those in favor? That passes 4-3. I guess you want to fill in the blanks.
Yes, we have to start with section 1.
Before you fill in the blank, may I just, you have a record here, I would imagine. May I say something for your record? Okay. Would you mind if I say something for your record?
It's okay with you, counsel? Do you want to go through with you?
Sir,
Is it okay with you? Or you want to go through with it?
Do you mind if I say something for the record?
I'm prepared to go through.
For it.
Is it okay with you?
Mr. Mayor, you're the chair.
Okay, great. All right, so I wanted to just be clear that the resolution that this council has passed, that being City Councilwoman Naima Gilliard, City Councilwoman Rosie Jackson, City Councilman Khalid Kamal, and City Councilman Mark Baker, is the same resolution that was presented to them on record by Mr. Morosic, hour and a half by email prior to this meeting, wherein they had absolutely no input. I also want to make sure that the record is reflective of the point that the city attorney, that Mr. Morosic, one, has identified himself as special city attorney. Nobody on this body has appointed him as a special city attorney, and the charter identifies him to be the special investigative hearing officer, or excuse me, the investigative hearing person, or prosecutor, or whatever term, but it certainly does not identify him to be the special attorney general, a special city attorney. The other thing that is important for the record that I would want to make note of, and this is my last point, is that the city attorney, one, had received prior to appointing Attorney Morosic a letter from me identifying that she had a conflict. Instead of her responding to my letter, she passed said letter on to Mr. Morosic, and in that letter, not only did I identify her conflict, but I also identified the fact that she herself, and I want to make sure the record reflects this, she herself was not appointed as a city attorney for the city of South Fulton, but that she was actually, according to what I read in the charter, and this will be fleshed out in the Superior Court this week, that the mayor made an appointment of the city attorney, which I believe at some point, for whatever reason, went awry, and that she became the city attorney, but I could not find anything that officially appointed her. So to that extent, I'm going to be asking the Superior Court of Fulton County to issue a declaratory judgment to determine whether or not she can even serve the city as a city attorney. I'm done.
That's how they gonna get rid of you.
Mr. Morosic, go right ahead.
Section 1 of the resolution, Section 1. The council has determined that it is appropriate to schedule an investigative hearing to consider the removal from office, sanction, reprimand, disqualification, censure, or removal, current and/or prospective, by council under Charter Section 216 of the following members of council.
I'm concentrating.
And I'll ask,
Excuse me a minute. I can't hear the attorney in all this other conversation. But go ahead and make your point.
Section 1, as I just read, is to identify who is it council wants to investigate at the investigative hearing on December 30th. It's that simple. Fill in the blanks with a majority vote.
Hearing nothing, go ahead.
You gotta fill this out.
And you want us to fill it out?
Yes, I'd like some, you decide who gets investigated. You can decide no one gets investigated, and allow me to make a motion if I might. I'd like to make a motion.
I'm sorry, Councilor.
To fire me.
Hold on.
I will second the motion.
Well,
You all want to fire me. But I want you to.
can't make a motion now.
I know. So it's denied.
Yeah, all right. It was funny, but it wasn't good.
Section 1.
All right.
Who is it that will be the subject of the investigative hearing on December 30th? That's section 1.
So do you want feedback as individual as to what people say?
I want you to decide it under parliamentary procedure, Mr. Mayor.
And it could be
Motion and a vote.
one person or more than one person.
Or no.
Or no persons.
You looking for a number or a name?
I'd like to make a motion.
No, excuse me, I'm asking a
Poll.
question.
Poll.
Huh?
Poll.
Okay. All right. I'll entertain a motion.
I'd like to make a motion to include Councilwoman Willis in this investigative hearing pursuant to the provisions of this resolution.
Second. Probably moved to second. Any discussion? Hearing none, all those in favor?
Aye.
That passes 42. 43, rather.
And what was the vote, Mr. Mayor? 43.
43.
Okay.
Can I,
No, go ahead.
he's got to recognize you.
Let me ask you something. Is that all you want out of this? You got some more blanks to fill in, right?
It's a point of parliamentary procedure, Your Honor.
You keep telling me that. I'm just asking a question. There are several
I'd like
blanks in here. You want to go through all of these?
Yes, sir.
Okay. Ms. Jackson, go ahead.
Yes, sir, that's my intention.
Okay, Ms. Jackson, go ahead.
Okay, I move to include Mayor William Bill Edwards in the investigation and removal hearing on December 30th under the same provision of this resolution.
Second.
Been moved and second. Any discussion? What am I being charged with?
Well, your name was
Okay.
called that you called Helen.
A name was called.
No,
so
you,
charged
they
me.
said you called Helen.
Okay. All right, no problem. All in favor? 4-3.
I didn't hear the second, I apologize. The
Mr.
second,
Khalid.
I was just wondering, okay, thank you, my apologies, thank you, I apologize.
May I proceed with section 2, Mr. Mayor?
You sure can.
Okay. Section 2, an investigative hearing shall take place on December 30th, 2019 at, you decide what time it starts, at the following location, 4645 Butner Road, Atlanta, Georgia, for the purpose of consideration of removal from office, sanction, reprimand, disqualification, censor, or removal, current and or prospective of Mayor Willis and Councilmember Mayor Edwards and Councilmember Willis.
I make a motion to have that hearing take place at 9 a.m. here at City Hall, 5440 Fulton Industrial Boulevard, Atlanta, Georgia, 30336.
Second.
Probably moved and second. Discussion, Ms. Rawl, I'll start in your hands.
A question, and this is for council. Whatever action pursuant to the, whatever action that is taking place, if any of these considerations, would they no longer apply effective January 1st to Councilwoman Willis, and I guess it would not apply to the mayor, is that correct?
My read of the Georgia Constitution and talking to the folk under the Gold Dome is that even if this body votes to remove these people, it will be for less than 24 hours.
That's my, that was
Still
my
have the truth.
understanding.
Still got the
I still have the floor.
You still have the floor, ma'am. Go ahead.
Right, so, which is why we can continue down this road. It makes sense for ethics, because whether you think we should spend money or not, like you said, it's less than 24 hours. That's what I also heard from the legislators that day. And so if we're being transparent, the public needs to know that as well.
And I'll just be clear, I believe a legislature also said that, at least I heard him say that to Council Morrissey, and he disagreed, but he did say it.
I did not disagree. Let me know
I
what my response, this seems to be a problem, Attorney Weems.
So you,
Representative Bruce
Not on TV.
came to me and suggested that he thought, in his opinion, that removal of Councilmember Willis would be for one day. And my response to him was, I would like to know what the law is as well. If you would have the Legislative Council call me with a legal opinion, I believe it should be shared with the council. But I have not received that legal opinion. It is an unsettled point of Georgia law, and I'm not prepared to give a legal opinion. It's that simple. I respect Representative Bruce. I do not object to him making that suggestion. A lot of people in this room have made that suggestion. That's above my pay grade.
Mr. Khalid?
First, I would like to ask our special counsel, is there any stare decisis from any other state or jurisdiction that might have some persuasive authority contrary to what we just heard from Attorney Bruce?
May I respond, Mr. Mayor? Fascinating issue, and I've very much enjoyed researching it, and yes, billing the city for it, as I have billed the city substantially for preparing for an injunction hearing, which I asked council to give me notice, preferably not tomorrow morning between 9:30 and 2, but I'll be there. But I think the issue is, on a national level, also unresolved. But I think the issue comes down to, again, the city charter allows the city council of the city of South Fulton to do certain things. And the main constraint, and I take this seriously, is the 14th Amendment to the U.S. Constitution. On that, I would hope, council and I agree. But fairness is important, and that's the issue. Fairness involves notice and an opportunity for a hearing. So it's an unsettled point of law. I found cases from Iowa, California, New York, and the basic legal ruling I find is that you're permitted to go forward with this type of removal proceeding, but you have to handle the hearing in a fair way.
Thank you. Wait, I still have the floor? Thank you, because I want to make sure that we are meeting the constitutional requirements of due process under a fair notice in the hearing. So thank you for that. But the second point is the removal is for a term. And while Councilwoman Willis's term may end December 31st, the mayor's does not. So I just want to point that out. So this isn't a moot point, and it also is about principle. If only removed for a day, for $10 million coming up missing, that's a principle. That's a principle issue, and maybe it's not $10 million, but we're going to find out. So we're going to have a hearing. Thank you.
Okay, Ms. Gilliard?
Since we're talking about the record, I want to go on record to say that I was really upset that during our December 10th hearing, a ruling to dismiss the case was based on the fact that the mayor had not signed a resolution when the resolution was law. Once the council votes on any legislation, it becomes law, whether the mayor signs it or doesn't sign it. And that was used as one of the reasons to throw the case out. I want to make sure that that's in the record, because I find that very disturbing. I still do. We can keep going around and around on this. And, you know, as I look out into the audience, I know that there are people, you know, that have taken a position one way or the other. But to me, when you take a position and you don't have all the facts, what does that say about you and the way you process things? So that's what we're trying to get to. We're trying to get to the truth. We're trying to get to the facts, and we're struggling to get there. And every time we get almost up to the door, here comes a curveball, each and every time. But whether it comes out in a hearing or not, it's going to come out eventually. Everything usually does eventually.
Okay, let me add something for the record. It is correct that if I don't sign something within 10 days after that, it becomes law. No different to me than the mayor, than the governor, or the president of the United States. But before I sign a form, a document, and it's always been this way, the county city attorney should sign it because she's attesting to form. Now let me just take a few minutes to make my colleagues just think about back a minute. On Monday, July 19th, at 3:57 p.m., and I want this read into the minute, I sent a correspondence to Ms. Walker, and it reads as such. In my review of the charter of the city of South Fulton, section 3.21, submission of ordinances to the mayor, it states, every ordinance, resolution, or other action adopted by the city shall be presented to the mayor for signature within 5 business days. Following the adoption of such ordinance, resolution, or other action by the city, the mayor shall have the right to veto any ordinance adopted by the city in accordance with the procedures set forth in this section. Now, watch this. The city manager recently provided to me an extensive list upon my request of all outstanding legislation that are yet to be received by my office. Additionally, in the past, we have had legislation come across my desk with more than 30 days lapsed since adoption. This is a clear violation of the charter and prohibits me from performing the duties outlined in my role as mayor of the city of South Fulton. This is unacceptable and will no longer be tolerated. Beginning immediately, I am asking that you comply with the charter so that I can effectively and efficiently conduct the business of the city in a manner that is professional, timely, and in the best interest of the citizens of South Fulton. I wrote that, sir, July 8th, about not allowing me to have an opportunity to sign anything if I did want to sign it. Because it also violated my right to veto, if that's what I wanted to do.
You can't veto it.
And so, you just watch.
According to an ordinance.
Just watch.
According to the charter.
Okay.
You can only veto items.
Financial
Okay.
Budget.
Okay, all right. That's fine with you. Now let me talk, okay? So I'm just saying, is this issue about me signing? I got stuff in there right now. Am I correct, Mr. Clerk?
Yes.
That should have been signed, should have been on my desk.
I want to see
Ain't
it.
made my desk.
I want to see it.
Right now. So I just want to read this into the record, because the only thing I don't sign is something I don't want to sign because I don't agree with it. But that doesn't stop it from being law. Thank you. Go ahead.
For point of clarification, the hearing was dismissed not because the mayor did not sign it, but because it was not signed by the clerk and the attorney. And those are signatures that are required. So if you go back and look at December 10th, what was noticed, what was said is that the attorney did not sign. Am I correct, Attorney Weems?
You're correct.
The attorney did not sign it.
The attorney would have been Mr. Morose.
And the clerk did not sign it. So therefore, I did not have any official charges. Mayor Edwards is correct. He is not required to sign legislation, just like the governor is not required to sign legislation. After a certain period of time, if they don't sign it, it becomes law. So I just want to make sure that's clarified.
Kalika?
Lots of people talking that won't testify under oath. Lots of stuff being read into the record that people won't swear on the Bible and have questions asked of them under penalty of perjury. So let's get back to this document. Could we go on to the next item so that we can get through this document, and then, you know, people are going to do whatever they want to do to stop the hearing from going forward. But can we just do what we came here to do?
I want to have one more thing to say, Mr. Cleveland. If you want me to swear on a stack of Bible, on my mama's grave, or whatever you want me to swear on, bring it out, I'll swear on it. I will swear on it, so that's not the deal. Let me introduce you to another piece of documentation. This is a letter from Mr. John Morose. Before I answer that, are you hired by me? Are you my attorney?
I'm hired by the council.
So you're my attorney?
Yes, sir.
Okay. Mr. John Morose, concerning this so-called not signing of this document, the thread on this document goes to everybody except the clerk.
My mistake. I would have thought.
No, no, sir. It's a lot of mistakes being made. All right. I'm just saying, since y'all want to put me on the line.
Who is the clerk?
Excuse me.
Who is the clerk?
Excuse me. We got a clerk and assistant clerk. Let me finish. Since y'all want to put me on the line, let's come with it. there's nothing from you, Mr. Morosic, that goes to the clerk, nor does it go to the deputy clerk. So when would I have had opportunity to sign it? There is no opportunity for me to sign it because you didn't send it to the proper people. So I told you, call my name, you get me. All right? Because I have done nothing. If you call my name, you get me. Okay? Who's next?
Actually, there's a motion on the floor by Councilmember Khalid, seconded by Councilmember Jackson, to approve the investigative hearing for December 30th, 2019 at 9 a.m. Here at City Hall, 5440 Fulton Boulevard.
And the hearing shall start promptly and shall not be delayed or disrupted. Does the council agree or disagree?
Hold on, because I'm not sure that you could do that, because whoever the hearing officer is may determine that as the person who is presiding, right?
There is no presiding hearing officer.
Exactly.
I'm sorry, point of order. We made a motion that
That'll
was
be dealt with
seconded.
later in the resolution.
And I'm
We
about
made a motion that was seconded and passed
and I'm about
to go line by line through every blank on this document. We're going to go line by line through every blank on this document, and all of these questions will be answered. Right now, there is a motion on the floor to have the hearing at 9 a.m. at City Hall at 5444 Industrial
There is a
Boulevard.
discussion on that motion.
I move the previous question.
You were never recognized.
You ain't gonna move the previous question when the one has already been recognized and discussed. Go ahead and make a discussion, then you can move the previous question.
Yes. This room is not big enough. Second of all, how can you all make a hearing for 9 a.m. without making sure my attorney is available? This is not a one-sided, if you're gonna be fair, you're gonna be objective, and now that the mayor is included in this investigative hearing, he's gonna have an attorney. Because according to our city attorney, this attorney is not gonna be neutral towards me. She said that. He's supposed to be representing all of us, but he's not being neutral. You told me that I needed to get my attorney because this attorney that was hired by council is not going to be neutral towards me.
What I told you is I said I felt that because your interests were in conflict with the city, that it would be in your best interest before you communicated anything about this proceeding to hire outside counsel.
You told me that Mr. Morosic was not going to be neutral towards me.
He was not going to protect your individual
Point of order,
interests.
Mr. Mayor.
Okay,
Excuse me, you're not a member of this council.
Point of order, Mr. Mayor. It is the privilege of this council to call for this vote. I am a member of this council.
I made a decision. I said she was speaking, then we'll call for the vote.
Okay.
So I don't think that a hearing should be scheduled without the consensus of all individual counsel that has to be involved. It's unfair and it's not being objective.
Okay.
Attorney Weeds, are you available that day and that time?
No, it's 10 days.
Is the mayor attorney gonna be available that day and time? He said he's gonna address the hearing, judge later on. And then this place is not big enough. I yield to Councilmember Rao. I yield to Councilmember
Go
Rao.
ahead, Ms. Rao.
Yeah, this is just disturbing on so many levels that
It really
I
is.
really don't have, I don't have anything to say at this time. I know people who elected us didn't.
Okay.
This complete circus.
All right,
Ridiculous.
let's vote on the motion. That passes 4-3.
Next item, the hearing shall start promptly and shall not be delayed or disrupted. Does the council agree or disagree?
I move to approve that clause.
Second.
May I be heard, please?
Yes, you can.
I would ask this body to reserve making a decision on that matter until the Superior Court has ruled on whether or not it is legal for this council to determine whether or not a hearing can start or stop without interruption.
There's no pending matter in the Superior Court. There's nothing to consider. Council's had until Thursday night to petition for such relief. File a petition. We'll be happy to meet you down there. There's no pending petition in the Superior Court.
I appreciate council saying that, but I didn't know, just like y'all didn't know that this existed until an hour before. So now that I know that it exists, I certainly have just the same way he came and brought it before you. I have the right to bring before you my request. At the end of the day, Mr. Morosic doesn't live in the city of South Fulton. I don't want him to get y'all in any trouble, in more trouble than he's already got you. So what I'm asking you to do is to please preserve your ruling on this matter until a Superior Court judge of competent jurisdiction can rule on this issue. That's all I'm asking.
I would, what is, could you, for my sake, define delayed or disrupted?
The hearing will start as scheduled by the City Council according to its charter. There will be no continuance or disruption.
So
That's your choice, yes or
okay,
no.
so means that everybody has to be here in place at the time of the meeting.
Not everyone has to be here unless they're subpoenaed,
That's,
but
no, I'm saying if I
for a
start,
council meeting to convene, correct,
there had to be at least 4 of us to be in the council.
correct.
And that's what you mean if you say delayed, right?
Delayed, waiting a half an hour, waiting 3 days, starts
I'm
when
just
the
trying to-
council schedules.
Okay, Mr. Rosick, I'm just trying to figure out, that applies to any delay from our end, right?
Anyone's delayed, including my own.
Gotcha. All right, cool.
What it also means is that if there are preliminary motions that are filed, that the hearing officer, whoever he or she is, has to rule on, if you agree to this, Attorney Rosick making you commit that you will ignore the hearing officer and that you will go forward.
Point of correction, the hearing officer is not empowered. Your charter does not use the word hearing officer. It's nowhere found in your charter. I suggested the hearing officer for one simple reason. Let's discuss what the role of counsel is. Counsel decides those questions. You are allowed to serve simultaneously in an adjudicative and prosecutorial function. That's the law. Your charter allows you the opportunity to remove, if you choose, a member of council. So you're acting as prosecutor and you're acting as the jury. You decide the issues, not a hearing officer. Mrs. Moore stepped way over the
Judge
authority she
Moore.
was given.
You will not
Give me counsel,
She was given, she exceeded her authority.
If she exceeded it,
counsel.
My apologies,
Let him go
Mr.
ahead.
Mayor.
Go ahead.
I think I stated my point, Mr. Mayor.
If she exceeded her authority, it was only at the concession of the two of us with acquiescence by more than one conversation that we had with her on the phone. What you won't do is, I'm talking, I'm still talking. What you won't do is disrespect Thelma Moore. You would not disrespect her.
Okay.
Well, and in addition, if I might please, and the last thing I will say is, if this council can serve as both prosecutor and jury, then why is he here?
Okay. No, we are, what's the motion?
To approve
Motion
this.
is, motion by Councilmember Khalid, seconded by Councilmember Baker to approve that the hearing shall start promptly and shall not be delayed or disrupted.
All right, let's vote. That passes 4-3.
Next, section 3. These are, again, issues of evidence. Issues regarding the introduction of evidence are decided by this council. That's the law. And I'm going to ask you to decide 3 evidentiary issues. One was already decided affirmatively. We're not going back to that. We're doing a new resolution, and we're going to do it right. Takes more time, takes more effort. We're going to do it right. 3 issues, I'll just outline what they are. The first is Georgia Sunshine Law or Open Meetings Act at OCGA 50-14-1 requires meetings of municipal corporations and other agencies where official actions are taken to be open to the public. The deliberations of the investigative hearing shall or shall not be conducted in public. Mark 1, vote. That's the first issue. Whether or not you'll deliberate the investigative hearing in private or in public. The evidence must be taken publicly, The decision must be taken publicly, but deliberation is an exemption to which you're entitled to waive or do it privately.
Mr. Baker, go ahead.
I'd like to make a motion to keep everything public, even in deliberation.
Second.
Properly moved and second. Any discussion? Hearing none, all those in favor? Passes 4-3.
Okay, the second request for an evidentiary ruling is further, the council agrees or does not agree to waive executive session privilege relating to conduct of mayor and council in executive session meetings. Mark 1 and vote.
I'll make a motion to waive executive session privilege relating to the conduct of the mayor and council in executive session meetings.
Second.
When you waive that, I don't care about the language. When you waive that privilege of a statement being made in executive session, you also put it in the context of why the statement was made? Or you just saying, I don't like you? That was a statement that was made. But you don't hear the fact that somebody said, I don't like you. Right? So I just want to be fair. And I want to know if statements being made, I want to know the context of the statement.
All parties will be allowed full examination and the right to a thorough right of cross-examination of these matters.
So your answer is no, they will not be put in context.
No, they'll be put in context as you choose that to be, Mr. Mayor.
Mr. Baker, that got you?
No, I'm clear.
Okay. Ms. Willis?
Council Attorney Williams, is it legal to waive executive session rights? Isn't this something that's supposed to be done by the Superior Court judge?
It is my opinion that I would ask, I'm going to defer to my learned brother in the law to ask him to give you a legal opinion as to whether or not it is legal to waive executive session.
Absolutely, yes.
And now I'm going to ask you, if you would be so kind, as to table this until you have gotten a concurrent opinion from the Attorney General of the state of Georgia, which I intend to ask for tomorrow. And the record shows that Attorney Morosek said yes.
Go ahead to the next one. Did we take a vote on that?
Nope.
All right.
No.
Let's vote, please. Well, we waive the executive. Okay, that's 4-3.
The final evidentiary privilege is as follows. Further, the council agrees or does not agree to waive attorney-client privilege relating to any communications, verbal or written, of any member of mayor and council with or to City Attorney Emilia Walker regarding the Halpern's expansion deal, which was the subject of a Fulton County Development Authority meeting October 22nd, 2019. Mark 1.
This is section 1. What section are you reading from? What section are you reading from?
This is the final sentence of section 3.
Okay, I got you.
Yeah, I see it.
So, Mr. Mayor, if I may.
Go right ahead, sir.
Can you map that out in layman's terms?
Yes, sir. Again, this is the attorney-client privilege issue, which has been resolutely resolved under all 50 states, including Georgia, that communications between an attorney and a client are confidential. The best example I can give you is if a client tells his or her attorney where a murder weapon is, the attorney may not disclose it. It's confidential. However, that privilege may be waived not by the attorney, never by the attorney, but the privilege may be waived by the client. And in this case, the attorney-client privilege is clearly held by this body. We solicited an opinion from the Georgia Bar, and they repeated what is black letter law. The attorney-client privilege belongs to not any one of you, it belongs to all of you. And I believe your city attorney, as all city attorneys, as I've been a city attorney, tells members of mayor and council, this is a confidential communication between us and the world, but everyone else on the council shares in what you tell me. So the simple fact is that the attorney-client privilege regarding communications by each and every one of you with Attorney Walker regarding the Halpern's deal would be waived and subject to public disclosure and questioning.
I'd like to make a motion to approve.
If I might be heard,
It's a discussion, go ahead.
council indicated this is something that is going to be very pertinent. Council indicated that there was a ruling from the State Bar of Georgia. I would ask you to read it into the record if you don't mind.
I don't have it available in
I have it. Would you mind if I read it into
the
the record?
opinion that I gave.
Not only the opinion, but the question asked.
Council, feel free to read anything in the record.
I'm just pulling it up now. My apologies for the. It says, question, and this question is from, well, I'm sorry, that's the answer, my apologies. It says, this is from Dear Bar, this is from Attorney Emilia Walker, which is sent from ewalker@fincherdenmark.com to Leah Burgess. Question, Dear Bar, any feedback you may provide by 5 p.m. this Tuesday, i.e. 12/10/2019, and this was sent to her on December 9th, 2019 at 10:32 and 59 seconds a.m. Eastern Standard Time. Any feedback that you may provide by 5 p.m. this Tuesday, 12/10/19 is appreciated. I am a city attorney. The city council hired an outside attorney to bring disciplinary proceedings against one of its members. The member asked me by text to stop my efforts to prevent the city's loss of a development deal. The outside attorney plans to use the member's text to me as evidence at a disciplinary hearing. It is my understanding that the member's private attorney does not want me to disclose the member's comments on grounds of attorney-client privilege. My understanding of professional conduct rule 1.13 is that the city is the client and the individual member a constituent. I have never represented the member individually. As such, the city may waive its attorney-client privilege as to the member's correspondence to me concerning the development deal and ask me to disclose the same at the public hearing. Is this also the bar's understanding? Any assistance you may provide before 12/10 hearing is appreciated. Thanks. And she came back to say the entity, city in this case, is your client to whom you owe your professional duties. However, it cannot act except through its officers, directors, employees, shareholders, and other constituents. When one of the constituents of an organization client communicates with an organization's lawyer in that person's organizational capacity, the communication is protected by Rule 1.6 the confidentiality rule. There are exceptions. For instance, a lawyer can reveal confidential information to prevent harm or substantial financial loss to another as a result of client criminal conduct. Overall, your duty is to the entity, and when the interests of the entity are in conflict with the interests of one of its constituents, or a member asks you to do something that is not in the best interest of the entity, the lawyer must remain loyal to the organization. Based upon this, my interpretation would be that you could disclose the context of the text as your duty is to the city, and as the member's text is in opposition to or in conflict with the city, the duty to the city trumps. So if this body hears what I've just read to you, the question asked gave the impression based on what was said was, this person, and I'll reread it, just real quick for the record. It says that this person has asked me to do something against the interests of the city. So the question to
No, that's
I'm
not
sorry.
Go ahead. What I said.
Don't say what I said, don't.
No, point of order, Mr. Mayor.
That's not what they
He
said.
was asked to read the black letter law, not communications back and forth.
Right.
We are now litigating the hearing. I'm going to make a substitute motion to suspend all debate and just vote on each one of these items. Because he's already told us that tomorrow he's going to go to Fulton County and try and keep you all from hearing all this evidence anyway. So we don't need to have the hearing today and then again tomorrow at Fulton County. My motion is to suspend all debate and to simply vote on each of the questions in this resolution.
Second.
Properly moved and second. Any further discussion? Hearing none, all those in favor? 4-3. Go right ahead.
Your motion already made.
We have a motion on the floor, what was it?
Yes. Motion on the floor by Mr. Baker, seconded by Councilmember Jackson, to waive attorney-client privilege related to any communications, verbal or written, of any member of mayor and council with or to city attorney Emilia Walker regarding the Halpin's expansion bill.
Let's vote. That's 6-1.
If I understand that the ruling, the council's agreeing to waive the privilege?
Yes.
6-1?
Yes.
Thank you. Okay, the next item is section 4. The investigative hearing shall require the issuance of subpoenas for the purpose of securing witnesses and other documents. Special City Attorney John W. Morosek individually shall be vested with the municipality's legislative authority to issue subpoenas incorporating the powers given to counsel of record under Georgia law found in OCGA 24-13-21. Subpoenas issued by the council may be served in the same manner as service of subpoenas is outlined in the official code of Georgia annotated. Service of subpoenas may also be waived by witnesses, in which case the witness will have waived any objection to the sufficiency of service of the subpoena and will not raise process or service of process in defense of abiding by the terms of the subpoena. Council approves, does not approve the authorization to Special City Attorney John W. Morosek to execute and issue subpoenas. Mark 1, vote.
I make a motion to approve.
Second.
Properly moved and second. Let's vote.
Discussion.
You said no discussion.
Well, how long will this be served?
Neither you nor me.
Okay, that's fine.
Yeah.
Vote 4-3?
Yeah. No, 6-1. 6-1.
6-1.
Okay, we're on number 5.
Number 5.
And I would ask, for the sake of the process server, will Councilmember Willis and Mayor Edwards accept service of process of a notice of hearing?
Sir, I know you're not talking to my client without going through me on this one part complaint.
I'm asking Councilmember Willis and Mayor Edwards, will you accept service of process of a notice of hearing and a subpoena?
Well, speaking for myself, you serve me now.
Thank you,
I
sir.
have no problem. I get service every week.
Thank you, sir.
About something.
Yes, sir.
Attorney Weed, you can respond.
Don't say anything to my client Yeah, all 2 weeks,
Okay.
sir. The
That's
next
your
time
answer.
you violate it, you will
That's
receive
enough.
proper fine.
That's your answer.
55 Marietta Street.
Okay,
It's one-on-one area.
let's go on to the next item.
Next item, the charter at section 2.16 specifies that the city investigative hearing is convened after 10 days' notice to the member or members sought to be removed and empowers the council to set the procedural rules. The council hereby authorizes all procedural and evidentiary matters to be decided by the council in compliance with constitutional requirements of due process. Therefore, council will and shall give each side the opportunity to present evidence and to present argument, and will decide the conduct and total length of the hearing. Members of council may make any motion it deems necessary regarding the conduct of the meeting. Council approves or does not approve all of the foregoing. Mark 1, vote.
I'd like to make a motion to approve.
Second.
Let's vote. That passes 4-3. 5.
5-2?
What was it, what did they vote on? Can you repeat? Can you have them repeat?
Okay.
Yes, please do. What are they voting on? Clerk?
The council hereby authorizes all procedural and evidentiary matters to be decided by the council in compliance with constitutional requirements of due process. Therefore, council will and shall give each side the opportunity to present evidence and to present arguments, and will decide the conduct and total length of the hearing. Members of the council may make any motions it deems necessary regarding the conduct of the meeting. And the vote was 5-2 to approve of that foregoing.
Finally, the issue of the designation and role of a hearing officer shall be left in the discretion of Special Attorney John Morosek, since neither council or Councilwoman Willis nor anyone else has suggested any candidates in the week since the December 10th hearing, and since time is drawing near to the hearing. Council approves or does not approve all of the foregoing.
I'm sorry, I would ask for the record, I'm sorry, I would ask that the record reflect that at no point in time has Attorney Morosek.
Go ahead. I'm gonna let them vote. All those in favor?
Well, we have to make the motion first. We should follow parliamentary
I make
procedure.
a motion that we give Attorney Morosek the authority to appoint.
Read the motion.
You want to read the motion?
Section 6, the council hereby approves the attached notice of hearing as providing adequate notice to the members being sought. No,
That's
I'm
not
wrong.
Read it, please.
I did have the motion.
The issue of designation and role of a hearing officer should be left in the discretion of Special Attorney John Morosek, since neither council
I see.
for Councilmember Willis nor anyone else has suggested any candidates in the week since the December 10th hearing and since time is drawing near to the hearing.
Okay. I make a motion on that.
I second the approval.
Probably second, let's vote. Passes 4-3.
So we can't have discussion.
Section 6, the council hereby approves the attached notice of hearing as providing adequate notice to the members being sought to be removed on December 30th, 2019, as specified in Section 2, and hereby authorizes Special City Attorney John W. Morosek to execute and issue the notice of the hearing. Council approves, does not approve, all of the foregoing. Mark 1, vote.
Let's vote.
I make a motion to approve the notice of hearing.
Second.
Probably move the second, let's vote. Passes 4-3.
That completes the resolution. May I present it to you, Mr. Mayor, for your signature?
How can you sign something as the prosecutor?
Okay? I handed to,
It will be,
I would ask Attorney Walker if she will approve as to form. I have already approved it as special city attorney. If you decline, we will sign it. If you decline it, I signed it.
If you can sign, and then I'll also approve as to form.
Okay? And Mr. Mayor, I'd ask, who is the city clerk? Mr. Adams? I'd ask Mr. Adams to attest to the resolution, if you would. Thank you.
Mr. Rosick, I think even if the mayor doesn't sign, I think you should still have the clerk give him a copy for.
We will. I'll be happy to copy it.
Okay.
Mr. Mayor, I have a question. Can you recognize me? So just to be clear, you or I do not have any subpoena powers. We don't have anyone that can serve our subpoena. We can't subpoena.
I will execute subpoenas that are listed. I'll come to City Hall and execute them. You're entitled to subpoena witnesses.
I talk to the mayor, I'll talk to them.
Go ahead.
that is my understanding, is that you have, that the person who is prosecuting both of you have taken away your ability to subpoena people to testify on your behalf.
Thank you, Attorney.
And he did, and I just so the record reflect, he did state that he wanted to do it right this time, so I'm imagining he's gonna write a refund check to the city for all the money he did, when he did it wrong the first time.
Mr. Mayor?
Yes.
I would like to note, as one of the people that voted affirmatively for that motion, that my legislative intent was not to deny anyone the right to subpoena. That is not my legislative intent, nor do I believe it is the legislative intent of the majority. If we need to take a vote on the record so that our legislative intent is clear, I would like to make a motion for us to do a roll call vote about our legislative intent to deny the mayor or Councilwoman Willis the right to subpoena.
Second, just
For
for
the
the record.
motion, I would say the motion would be to clarify that Mr. Rosick is authorized and shall, upon request of any party, execute subpoenas.
I would like to make the motion as stated.
Probably move the second discussion.
Yes, Mr. Morosic, I would like the record to reflect is the prosecuting attorney and also is the prosecuting attorney for the city against Mayor Edwards and myself. Please reflect that in the record.
Any other discussion? Hearing none, all those in favor? Passes 6-1.
I would like to make a motion to go to executive session for personnel, litigation, and real estate.
Second.
Probably move the second. In discussion? Hearing none.
Yes, I would like to make a friendly amendment that we go to executive session in about 5 minutes to give us a five-minute break.
Is that okay with you, Mr. Khalid?
That's fine with me.
All right. All right. We're gonna go into executive
So
session.
we need a 10-minute break.
5 minutes. break.
5 minutes. 5 minutes
Okay.
was on the floor. I accept it.
All right. All right. You accept it? All those in favor?
Where's the executive session?
I can. All right, 5 minutes, then we're going to break session.
I'm sorry, we didn't vote. Did we vote? Okay.
I'll entertain a motion to reconvene.
I make a motion to reconvene from executive session.
Second.
Properly moved to second. All those in favor?
Reconvene.
All right. Would make, Madam Attorney, is there anything we want to vote on from the executive session?
Yes. I'd like to make a motion to approve the city attorney's contract as written.
Second. Properly moved to second. Any discussion? Ms. Rob, go ahead.
There's a provision related to the length of time or the number of votes to take any action that I thought we had agreed that it would not be included to move forward.
I'm going to address that in my next motion.
But you said it's read, it's presented.
Yeah, I did.
Yeah, you did. You amending your motion?
No.
Okay. All those in favor? Are you going? Oh. That's 4-2.
We did not agree to that.
You have another motion?
Yes, I make a motion to instruct the city manager by the end of this month to issue a 30-day RFP for consultants to review our charter and bring back recommended amendments to our charter in a public work session in February.
That's kind of not what she said. I thought we agreed too that she's not here. We were going to that issue that we thought was against the charter, which is would mean that you had to take 5 votes.
Yeah.
So my motion is to cure that issue by issuing an RFP to have a consultant come to us in February and make recommended charter amendments. Unless someone is planning to make a motion to fire our city attorney before February, I'm pretty sure that we can go ahead and approve her contract and then hire consultants to make sure that her contract is in alignment with our charter and that our charter is in alignment with itself.
Second.
Let me just say this. You all are approving something that I feel directly goes against the charter, and you want to cure it now. Why would I want to go over there and do what you asked him to do, Mr. Khalid, and wait 30 days to find out you was wrong?
Because we can't cure the charter now. It takes three.
You can cure it because it violates the charter. You can cure it that way with no question.
I think that's a matter of debate. That's why we need to bring in the consultants.
It's not in the charter, it doesn't violate it.
The charter is not clear.
The charter is very clear.
No, it's not.
It's very clear on this issue. But you know what? Go ahead on. Get your phone book.
What does it say?
That's what you want.
What does it say?
Right, go ahead.
What does the charter speak to?
He says she is the charter says nothing about her having to get 5 votes to
Right.
be removed.
What does it say?
It does.
Explain
That's
that.
a majority.
No, it doesn't say majority, it says that I serve the council's pleasure.
At the
That means
council.
that means that whatever you decide is gonna be my service, I'm subject to that.
But you,
We've already voted on that. We've already approved that. So now we're voting on
We're
it.
in this. Did we approve it?
Yes.
Mr. Khalid.
No, let him go ahead on. He already voted on it. No problem.
So now we have a new motion on the floor for the RFP. Yes.
So for the RFP, you're giving us 30 days to put it out and procure, but not to deliver the service. The service will come after, right?
Right.
We'll have 30 days.
No, I'm giving you to the end of the month to put out the RFP. I'm giving to the end of January for respondents to come back with their proposals, and I'm asking that they make their proposals in a public meeting in February. That was the motion.
And so this is where my question is.
Okay.
So the universities, the state institutions like Carl Vinson, they're the ones who actually do those charter reviews. They don't necessarily, you don't procure it that way. So they're on the state list, or you go directly to them. And so versus putting out an art, because they don't respond to those. That's what I'm saying. So we can reach out to them and get quotes within that time period and then bring those back. Does that make sense? They don't.
Can we clarify the motion to be to take all lawful means necessary to procure by the
Yeah.
city?
To make all lawful, I'll make the substitute motion to procure all, to make all lawful means to procure a consultant by January 31st.
Which includes the conference, right?
Which includes
Legislative.
your legislative,
I mean, if you're gonna bring me something back, you know, they're the ones who did the charge.
Well, I think
So what
they
you bring
should
it back,
use-
That's not my
No, no,
motion.
what he's saying is, he wants us to use an appropriate person
I got that
to
part.
adjust and do the charter.
I got that part.
What I'm saying is great, but they don't, so let's say you use Georgia State, Carl Vinson, and Clayton State, let's say all three of them, they're institutions. They wouldn't respond to the RFP. The state law has you go directly to them. They give you a quote, a scope, etc. And I believe that the council wants to review those options, like who is the best. And so that,
So my motion would be to use all legal means to procure an academic institution with a school of government by January 31st.
Okay, can we do that?
And where are those funds coming from? Yeah. Where are the funds coming?
Legal.
Legal. What is legal? What you mean? Her money?
Legal budget.
You have a budget?
That's not in our budget for that.
It's in her budget?
No, it's not in the budget.
Well, excuse me, I'm asking the CFO, I mean the treasurer.
It's to do with the review of the charter, which will be, otherwise unless you assign that it will come from the legal.
And the legal is what? Explain that.
It's legal budget.
It's
he's
the
saying,
money.
It's in the budget.
The line item.
Line item.
That's, what's her salary coming out of?
It's from the legal.
That's all I want.
And what,
Her budget?
Matt, can I say?
That's what, he said legal. He identified it. Her budget's in legal. Any other expenses come out, they already said legal, right?
This one is to do with the review, and it has to be from the legal
Line item.
line item of the budget.
So we got two line items.
One is what one?
I'm asking.
We have only one.
Mayor,
but it's more than her salary. You have to let them know that. They don't know that.
I'm sorry, point of order. We've never needed a fist for a motion. You have until the 31st to do the procurement, and in that time, you can bring back a recommendation.
Excuse me, unless you sitting right here, I'll have the floor. I'm not gonna take a whole bunch of outbursts. I'm asking a question, and I still haven't gotten an understanding. There are two, you're saying there are two legal lines?
So in the legal line, you have what is paid to the legal attorney. You have in the legal, that's where you pay for other litigation.
Okay.
So you have more than one activities in that line item that can be done, more than one.
Thank you, sir. That's exactly what I want to hear. All right. Ms. Willis, and then we're gonna vote.
Yes, and so, I just wanna go on record to state that that agreement, we did not agree to move forward with approving that agreement because it is in conflict with the charter, plus the amount that was put in that agreement was, is not budgeted for what we budgeted for, so it's gonna require a budget amendment, correct? Talking to the CFO.
So you will need the budget amendment if you don't have enough. But unless you say where it will be, that's the area that I have to charge.
And so, thank you for that, responding for that. And then, we also are supposed to have financial impact statements that wasn't done. So there is clearly a lot of stuff that was not done, but it's okay. Mayor, what I would ask for you to do is veto the action that was just taken, because it does impact our budget line item. Thank you.
Okay, Ms. Rowland, Ms. Gilliard.
I honestly don't see why it should come out of the legal line. I'm thinking that there are other parts of the budget where it could come out of, and more than likely, because it's for the entire city and it's really specific and relates to the charter that's for the city. And it really, even though it's kind of sort of legal, I don't think it's gonna be that much money, but I just think that maybe you might need to take another look at the budget in terms of where it could possibly come from. And wait a minute, let me just say, and we have time to deal with that in terms of where it could possibly come from. I think, and kind of sort of know that one of the reasons why we're doing, or this is what I think, one of the reasons why we want to move forward with approving the contract is because it's something that should have occurred a long time ago. And it didn't. And we know what's happening politically in the city anyway. And we know that there are going to be changes come January the 1st. And we know that there's some things that we need to take care of before we get to that point, and we know why. And all of us know that, whether we want to deal with it or not. And so we just voted the way that we thought we needed to vote, based on the fact that all this time for our attorney not to have a contract, that contract is definitely needed, whether the charter is clear or not. She's done an excellent job, since she has been our attorney.
Okay, we're gonna have Ms. Rowland, then we're gonna move on.
I need to go home, and I'm trying to wait to vote. I need to go. I really do.
We had no objections on moving on. It was one provision.
Right.
One provision in this contract. We will never be able to move forward as a council when we sit up and we agree to something and we do something totally different.
Yes, we did.
That contract still doesn't have the duties lined out for the attorney. So it's not a perfect document, but it provided some coverage. But to not only do something that we know that we didn't have agreement, and it's whether it's addressed in the charter or not, it's a gray area. That's not the right thing to do. It's not the right thing to do. And all of this to jump in front of a December 31st date on everything. I don't even generally go there, but it's just wrong. It's wrong.
Okay, let's repeat the motion, Mr. Clerk.
Jackson has a hand up.
I asked him to veto.
Jackson has a hand up.
The motion was
I said, when I did Mr. Rowland, we were gonna move on. Okay, what's the motion?
The motion was a motion by Councilmember Khalid, seconded by Councilmember Baker, to approve, to make all lawful efforts to procure a contractor, a consultant by January 31st, and to have a public meeting in February to make changes regarding the charter.
Let's vote.
I'm sorry, that wasn't my motion.
Okay, I'm sorry.
It was an academic institution
Academic
with the School of Political Science. School of Government, I'm sorry.
Yes, you made that correction.
I got it.
Okay, let's vote. That passes 4-3. I have a motion to adjourn. I'll entertain a motion to
I make
adjourn.
a motion to, I make a, no.
Yeah.
I make a motion that we proceed, we authorize the city manager with the procurement of the Southwest Arts Center on or about February 3rd, 2020, and acceptance of the service delivery model proposed by the staff.
Okay.
Second.
Properly moved to second. Any discussion? Hearing none, all those in favor? That passes unanimously. I need a motion to adjourn.
I make a motion to adjourn.
Probably move the second. Let's vote. All right. Thank you all for coming. Roast chicken.